We're going to start with the patent fee changes and talk about some mitigation strategies and big picture. We're going to talk about sort of the overview as the USPTO has put it in their CFR filings, and then we'll talk about filing fees that have changed, prosecution fees, and post-grant fees, and then we'll switch over and talk about the similar changes on the trademark side of things. So with that, let's talk about the patent fee changes and mitigation strategies for dealing with them. Um, First of all, at a glance, what is this all about? Why do we had this big fee change? What is the USPTO up to? Well, they are basically making everything more expensive across the board. You will see that on average, things are increasing, all the fees are increasing at least 7.5%. And the primary rationale for that is that it is to stabilize revenue and recover aggregate operational costs. USPTO actually publishes very detailed information on how much it costs them to do the various things that they do. And those things are associated with fees. And so you can see that they're doing a lot of tasks at a loss, which is quite familiar to patent attorneys that work on fixed fees. So the second thing is that they've focused on front-end fees, right? So whereas fees across the board might be going up on average 7.5%, fees on the front end, which are things like your filing, search, and examination fee, are typically going up a little bit more. Now, the USPTO says by an additional 2.5% for a total of 10, but we'll get into the actual numbers, and it's more like 9%, and some are 10%. And here again, the primary driver is recovering costs and sort of shifting the economics away from maintenance fees and closer, or I should say, to the front end of the patenting process. And then there's some targeted fee adjustments, and those things I think are really based on trying to sort of move US practice more towards foreign practices in some cases. Of course, the USPTO doesn't say that in their description, but if you look at sort of the things they're targeting, which is primarily around continuation applications, you'll see that there's a theme that the USPTO wants you to file applications sooner, prosecute them more quickly, and not be filing long serialized applications. So here is, if you were to distill the CFR report and all of the rationales for the various fees increases, and I will try not to read this whole thing to you all, but just big picture, cost recovery and sustainability, number one, you see that consistently. In other words, it's costing them more than they're charging applicants. Their strategic goals, one of those strategic goals is improving service delivery, which is to say reducing the time it takes to do things. And also another strategic goal is making sure that things like small entity and micro entity fees encourage innovation and get people filing patents. Of course, there's general economic pressures, right? Things have gotten more expensive across the board, and they are dealing with that by raising fees across the board. Support for discounts and incentives, that's what I was referring to just a minute ago with small and micro entities. Efficiency improvements, this seems quite aspirational, but I think here again, trying to get make sure that they have enough examiners, that they get paid enough, and that we can get through the backlog of things. Balancing innovation, access, and cost alignment. Here again, this is really about how much of the fees, when you look at the total patent lifecycle, come at the beginning versus the end through maintenance fees. And of course, the USPTO opened up the fees for comments and got a lot of them, including from the PPAC. And so the fees, and they actually listened to a lot of the comments. There was quite a few things that were proposed that, good news, bad news, could have been a lot worse than it ended up. So, and thankfully, we didn't get all of the proposed fee changes. So let's talk about the front end application fees. And what you see in terms of the table here on the right side is the old fees, the new fees, the dollar change, and the percentage change. And I will tell you all, we are not going to touch every fee in the USPTO's fee schedule today. We're going to touch on what I consider the most common fees, the things that if you're filing a patent application, you're almost certainly going to run into. And so I've also included in here both utility and design. So you can see in the table we have provisional and non-provisional utility or filing, search, and examination fees, the claim fees, and the design filing, search, and examination fees, as well as the prioritized examination. And again, I chose these because I think these are the things you would run into most often when it comes to filing. And what the USPTO's report said is that the filing, search, and examination fees for utility patents only covers 29% of the cost, of actually doing that for applicants. And again, that's because the financial model has been so backloaded in maintenance fees. So you see, we have increases on the utility side between 8 and 10%. I will, as you can see, the increase in the claim count is quite significant, right? For independent claims, you've got a 25% jump. And for just claim count above 20, you have a 100% jump. Now, that's still a pretty reasonable cost, but when you are thinking about applicants that may file typically a lot of claims, that 100% jump is definitely going to make an impact. The design fees are percentage-wise significantly increased. And this is because design fees, well, what the USPTO said is that design patent filings in the last 10 years are up 50%. So there's a lot more people filing design patents. And that's probably for various reasons, but I suspect one of them is related to a lot of graphical user interface type design patents. And with the fees, sorry, with the filings way up, but not even covering, half of the cost, that's an issue. That's why they're raising it. And one of the things that's interesting about the design patent side of things is that you have a high percentage of filings, over half the filings are the discounted filings, so that'd be the micro entity or the small entity. So when you think about cost recovery and you have 60 and 80% discounts for small and micro, you can see that there's a big subsidization gap between those. And so these big jump in design fees are really meant to help close that gap. If you see on the bottom right here, this is a table right out of the CFR, and it shows basically the amount of cost recovery, the dark bars, versus the actual cost, and you can see broken up by subsidy, the light bars. And you can see that over time, and this is specific to design applications, over time that gap has grown. And I just pointed out that in 2023, actually at the very end of 2022, we got the new further reduced small and micro entities, and you see that it had a pretty immediate impact on cost recovery. So that's where we are. What can we do about it? Well, on the utility side of things or design, using pre-filing searches may be one thing that's now worth the while, because if you can avoid filings that you would have otherwise made without doing a search, you can obviously save money in the aggregate. And this is particularly true for large volume filers. And I even think for small volume filers that patentability searches are really worthwhile because you always get some actionable intel. But now, if you have a constrained budget and you're dealing with these fairly large fee increases, something's got to give, right? And so one thing to do would be to add the relatively small cost of a patentability search and aim to either get back some of your budget by avoiding filings, or get back some of your budget by avoiding unnecessary office actions because you know more about the prior art upon filing. Just another concept is filing foreign first, and that could be either directly in a foreign country where you intended to foreign file anyways, or using the PCT. Obviously, the PCT is, from a filing fee perspective, typically more expensive than the US, but you're going to get a search report within 18 months or so, and you might use that search report to tailor where you go, so your aggregate budget might be improved. Then there's things like the UK, which has very inexpensive filing and search fees, and you get your search, you can request expedited search for free, and you get it very quickly. And so for a fairly nominal amount of money, you get a decent search report, and now you can make decisions. So that's just another idea, and that may run somewhat concurrent with the concept of a patentability search. And finally, utilizing what I would call bare independent claims. So you can imagine for a long time, like in the computer arts, for example, you would see claim sets that would have 7 method claims, 7 apparatus claims that were basically the method claims in apparatus form, and then you might have 6 CRM claims, right, for a total of 20. And when you think about how many claim concepts you're really having searched, it's 7, right? Because the symmetric claims are really not different concepts when you're using just a generic computer or a generic CRM. So you could instead do something where you file a method set or an apparatus set, whatever your primary set is, and have 17, 18 claims in that first set. And then let's say you did a method set with 18 claims, and then you did a bare apparatus that matched claim 1 as claim 19, and then maybe a bare CRM as claim 20. And the concept there is that you can get the USPTO to search more concepts. And typically what happens during prosecution is you lose some claims either because the art has them, or you're going to put them into the independent claim to get over art. And what you can do then is you can prosecute the primary set. And when you get to allowance, because you already have the independent claims in there, you can usually add symmetric claims in those bare independent claims at the end of prosecution, sometimes even through an examiner's amendment. And that way you haven't wasted those claims on looking at symmetric concepts. So, and that's the idea there, is to avoid the excess claim fees, right? You get more things searched, but you're not paying to have a bunch of excess symmetric claims. All right. So, by the way, April, I can't see the chat. If anyone has a question and wants to chime in, please do. I just can't see if that's happening.
Yeah. So there was one question that popped up. So does the 7.5 increase apply to maintenance fees when you stated across the board? What about fee relief or freezing for micro businesses? And I think you touched a little bit on this, but that's the first question to come in.
Yeah, thanks for that. We're going to talk explicitly about the maintenance fees in a couple of slides. So if it's okay, let's push that to when I can show you the actual data. So what about, now we've gotten past filing, right? We've dealt with those increases. What about prosecution? And here again, I have not covered every possible prosecution fee. I've covered those that I think you probably will pay during the course of a normal prosecution. And you can see here that the extension fees have gone up that general 7 to 8%. And then the big one here, though, is the RCE. The first one is up 10%, and the second and subsequent RCE is up 43%. That's a very significant change. And I actually found the USPTO's rationale here a little interesting, let's say. So their rationale was that the second RCE is actually more difficult for the examiner, and they need more time to do that, and so they need more cost, or they need more in fees, right, to cover their costs. Now, if you think about prosecution, typically as you go down the prosecution trail, unless you're entirely changing your claims, normally the issues are narrowing over time. And so if you think about how many issues you might have in the first RCE versus second, I would think, in my experience, that it's a narrower set of issues, and it actually would be less expensive for examiners at that second RCE stage. So what I think this is really about is that the USPTO is trying to dissuade applicants from having these long prosecution histories, right? They want to get to disposition sooner. And that's actually one of their stated rationales, is promoting compact prosecution. I just don't really buy the cost recovery aspect on the second one. One thing just to point out here is, as you all know, the AFCP program was sunsetted. It's no longer around. So when you're thinking about your budget for the year, let's say you have a portfolio of some given size and how much you might expect to spend this year. The one thing about AFCPs, they were not very useful for getting to allowance in the sense that you very rarely got an allowance out of an AFCP response and interview. But they were very valuable, I think, for pushing prosecution forward, because it was another sort of free look, so to speak, at prosecution. And what I mean by that is that if you had a final office action, you could file an AFCP response and you could get almost always another interview with the examiner after that. Whereas if you're just on final without AFCP, you don't have that right. The examiner doesn't have to take it. And so what that meant in practice, I think, is that you got to the finish line a little bit faster, and you probably in the aggregate paid fewer RCE fees because you had this extra interaction that didn't have a filing cost. Without AFCP now, I think probably applicants will see a net increase in the total RCEs over prosecution, given the same overall strategy, right? And that's just because you're no longer going to have this touch point of the AFC program. So what can we do about these type fees? Well, one is to be more realistic with your claims up front, right? If you have narrower claims, like let's say, for example, you ran a search and you know something about the art and you just are narrower, you hopefully will have fewer office actions, right? Because you'll dispose of the low hanging fruit, the easy art quickly and get to the more difficult issues. Another thing to consider is avoiding these generic independent claims that try to really cover multiple embodiments, because you're very likely to get those things either restricted out or the independent claim itself is never going to be allowable. And so you're going to have to, add claims and just sort of extend the prosecution timeline. And then, of course, just like starting out with more realistic claim scope, you can also be more aggressive with your amendments during prosecution, right? So if you get that first office action, taking sort of a more pragmatic approach to your amendments so that you can try to get there sooner in terms of allowance. Now, look, that is ultimately going to be very client and situation specific, right? Because there are certain technical domains where a narrower claim may still give value to the applicant, whereas there's other domains, like I think in the software space, especially with the risk of validity in litigation, that having narrower claims is probably an overall decent strategy. But you might imagine in the pharmaceutical space that it's worth fighting for, having, let's say, like a molecule or something that's the broadest possible allowable claim. So these mitigation concepts are sort of general thoughts. Of course, we would look at the specific circumstances and go from there. Another thing to consider is appealing more often. Of course, appealing is not inexpensive itself, but oftentimes when you look at the statistics, there are examiners that will be very, very difficult with traditional prosecution and very easy at the appeal stage. And whether that's because they don't like writing examiners' answers or they just have a tendency to issue weaker rejections, it could be any one of those things. But taking a sort of data-driven approach so that you can minimize the number of second RCEs you file, I think it is worthwhile. And we use a software service that gives us great statistics on examiners, and I think those are things that generally applicants can get a hold of. Okay, what about IDSs? This is one of the places where we got a major change, as in not only increased fees, but entirely new fees. And the deal is now that you can IDS up to 50, I guess up to 49 references. Sorry, no, 50. That's right. And that is for an increased fee, but it's not huge when you look at dollars. But if you start to go above that, you're now going to pay incremental fees. And so I put that asterisk there to point out that if you go from 50 to 51, you owe $200 to the USPTO. If you go from 100 to 101, and you've already paid the 200, you owe 500 cumulatively, which is to say you owe them another $300. You don't owe them another $500. And similarly, if you get to 201, you now owe the difference, right? So if you've already paid in 500, you owe 800. But let's say you're filing a new case and you came in with 201 references. In the new case, you would go straight to the $800 fee. The USPTO's rationale here is to discourage applicants from submitting a large volume of less relevant information and to streamline the examination process. I see this as a potentially challenging issue to deal with, right? Because you also have your duty of disclosure, right? And that duty is under Rule 56 is that if it's material and you are aware of it, you need to disclose it. And you don't have a duty to disclose cumulative references, but I think historically, applicants have always erred on the side of disclosure, right? Because better to not have the possibility that someone said, "Oh, well, turns out that wasn't cumulative. That was relevant. You didn't, you know, disclose it, and now there's a potential inequitable conduct issue." So we've always sort of erred. Well, now we have a tension, right, between paying more for the IDSs if we're going to err on the side of always disclosure uh, versus the USPTO telling us they don't want large volumes. So and this can become particularly problematic when you have let's say you're way down the family chain, you're on a third or fourth continuation, and in an area where the examiner has cited a lot of art. And historically, again, the approach has been to IDS everything so that it ends up on the front page of the issued patent, because there's a perceived benefit in litigation of being able to tell a jury, hey, look, to the extent that someone challenging validity has cited a piece of art that was cited during prosecution, the act or the patentee wants to be able to say, look, the USPT has already looked at this. So now this is more of a decision in terms of cost. So how do we deal with this? Well, one is that the MPEP actually allows in continuing applications for you to avoid resubmitting everything. And that's because the assumption is that the examiner will look at references in related applications, right? And one of the things you may consider doing is filing some sort of transmittal that explicitly invokes this rule, just so you're putting it on the record. Hey, examiner, I'm pointing out that you need to use MPEP 60902 and make sure you look at everything. And that way I don't have to IDS all the other things. You lose the perceived benefit of getting everything on the front page, but if you're in a position where you're filing a lot of IDSs with a lot of references, that may be worthwhile. Another thing, and similarly, because we never had this supplemental fee issue before, is it's been easy to just cross-reference things and just again err on the side of disclosure. Well, a lot of times those cross-referencing, it's just a CYA measure, right? It's not technically necessary, and so that may be something where you rethink that. And then a final thing is not citing non-prior art. And that may say, like, well, Nick, why in the world would you ever cite non-prior art? Well, this happens all the time, and some clients require it. Things like citing the PCT search report in written opinion, right? That is not a prior art document. It refers to prior art documents, but historically, a lot of clients have filed it anyways, just to, again, completely to err on the side of full disclosure. So if you're sitting there and you're at 50 and the 51st reference is the PCT search report, you might skip that to avoid the cost. So, all right, moving on. What about
Hey, Nick,
appeals?
you
I
do
mentioned
have
your.
another question.
Oh, I'm sorry.
Nick, you do
Yeah,
have
go ahead.
another question real quick about statistics on examiners. I think you mentioned that a slide ago. Do you mean as a whole or individual examiners?
I mean individual examiners. So there are, of course, statistics on tech centers and things like that, but we tend to look at specific examiner statistics. And if memory serves, I have a chart in here where I'm going to show you guys an example. So we'll get to that. But yeah, things like, so the Patent Advisor service that I believe is a product of LexisNexis, you can look up a specific examiner and you can see all sorts of data about, what their so-called ETA is, which is basically a measure of how difficult they are, how much interaction you're going to have. You can see, when you go into an appeal, how often you exit the appeal process at the notice, at the appeal brief, at the examiner's answer. There's really a lot of data, and sometimes it doesn't point to a clear path, but sometimes it really points to a clear path. And again, I think I have an example in here I'm going to show you with an examiner I've dealt with where her prosecution statistics were awful, and her office actions were awful. But in appeal, you won, just period. So we got into a habit of we would always appeal at the first final office action, and we basically never paid an RCE. And again, of course, we paid for the appeal, but having gone down the road of multiple RCs before, we knew that again in the aggregate that was actually a cheaper for the applicant. So, okay, ex parte appeal fees. Again, we have just sort of the normal across the board changes. And in here, the USPTO's rationale was, again, promoting compact prosecution. So, and their thought was, we want you all to find ways to get to allowance without having to go to appeal. The problem is that if you have a sticky examiner and you're not getting there on prosecution or like typical prosecution, right, office action responses, then you don't have a lot of options other than appealing. So, I think it's sort of difficult to suggest that this is actually going to promote a different strategy in terms of compacting prosecution. But of course, if you want to avoid appeals and RCEs in general, as we talked about before, taking a more realistic approach to your claim scope is one of the ways to avoid both of these. Again, we just talked about taking a data-driven approach. And one thing I want to point out is that this is both true of the examiner and the issue that you're dealing with, right? So I work almost exclusively in the computer arts, so a lot of software, a lot of AI. And unfortunately, that means I deal with a lot of 101 issues, 101 being the statute for subject matter eligibility. And at present, the overall win rate, like all time for 101 issues for subject matter eligibility is like you lose like 80% of the time. And unfortunately, it's getting worse. So if you look at the last 2 years, it's now you're losing 83% of the time. So you may have an examiner whose statistics are good in the sense that, like, if you go to appeal, you are more likely to win than, say, doing another RCE. But if you're going to that appeal and you're dealing with a difficult issue like 101, it may change the analysis there. And a tough conversation I have frequently with clients when we think, we've bottomed out with the examiner, the only approach is appeal, but we're dealing with a 101 issue. And you have to have that tough conversation, like, should we just abandon this case, right? Because if the going rate is maybe you'll win 17% of the time, it's sort of hard to spend the time and money on that. All right, sorry, I'm trying to advance the slide unsuccessfully. Here we go. Okay, terminal disclaimers and issue fees. So we're getting towards the end of prosecution, right? Here, the one thing to really note is the design issue fee. That's a 76%. That's a very significant cost increase. And again, here, this is really about the fact that design cases have gotten more popular. There's a lot more being filed, and there's a lot of subsidization of the design. Over half those cases are filed as smaller micro entities. So unfortunately, the undiscounted entities are really taking the brunt of the cost increase. Now, of course, I should have pointed out at the very beginning of the presentation, I have only showed undiscounted fees. All of the small and micro entity have the same relative changes. They just have different lower values, right? So there's no sense in having to show all the numbers. So small and micro entities are still paying a 76% increase on their issue fee. It's just their starting issue fee is a lot smaller. So here again, the rationale is addressing the actual cost. And here the USPTO talked about inflation. So what can we do to address these sorts of fees? Well, typically when you're at issue, you don't want to not issue the case, but you might think about, in the aggregate, filing fewer applications, right? Especially if those are like really speculative applications, because sometimes the speculative ones will, they may issue and that's great, but it may be that it's on something that's really, it's an edge case commercially for you, and it's not likely to be one that creates a real moat commercially for you. So you may have to give up on those just to avoid these fees, because obviously this isn't the last fee. Once you issue a case, maintenance fees come after that, and we'll talk about those fees in just a minute. So that's, again, that's one thing to consider. Also, you may get to this the average prosecution these days takes probably a year and a half to 2 years. And then when you consider that it probably took a year and a half to get to your first office action, so maybe you're 2 to 4 years down the road from when you filed something. Might be that the commercial value of the application just isn't there anymore. Maybe you moved in a different direction, the competitors moved in a different direction. And you have the opportunity here to say, it's tough. I got one. It's allowed. I want another one on the wall. But if there's really not commercial value there, you might consider just letting it go. Um, and finally, historically, restriction requirements, it's something we deal with, but you've almost never win a traversal argument on a restriction requirement. And so, historically, you deal with it. You take, withdraw the claims, and if they're valuable to you, you file a divisional later. And you typically don't fight hard. You might make an argument just to preserve your right for rejoinder later. But really, it's sort of one of those things where you're just never going to win. Well, I think you might need to rethink that now and how hard you fight a restriction requirement. I still think they're going to be very difficult to win. But, if you're trying to avoid dividing cases where you're now going to, one case is going to become two cases and technically two issue fees and two sets of maintenance fees, it may be that you have to push back on those a bit more. And also the way you draft your claim sets, trying to avoid obvious restriction issues is just a thought there. Okay, here is another, probably, I think, the most significant fee change on the patent side of things. So, and that is there are new time-based fees for continuing applications. What does that mean? It means that if, historically, it didn't matter if you filed a continuation, a year after your priority date or 18 years after your priority date. It was the same cost structure. But now it is not. If you file a continuation more than 6 years after what the USPTO calls your earliest benefit date, which I think you can safely assume in most cases is your priority date, you're going to pay a fee, $2,700 on top of all the other fees. And if it's more than 9 years, it is $4,000 on top. And the USPTO, in trying to justify this fee, said, look, people are filing a lot more continuing applications over, from 2010 to 2022, the number increased by 100%. And of those, continuations have tripled and represent 34% of all so-called serialized applications, which is to say an application where you're claiming priority back to a previous application. The rationale here, though, is that somehow this costs the USPTO more to deal with these applications that they're now very familiar with, which I think is really suspect. I don't think it's true. And if you read the rationale in the CFR, it just doesn't ring true to me. I think what this is about, as a sort of a shadow policy, is they just don't want people continuing to mine applications for long periods of time. If you look bottom right here, this is again a USPTO provided chart, and it's showing, sort of the percentage of cases that these new fees would apply to. And so you can see that the 6 to 9 year fee, which is that third bar, only applies to about 12%. And then the sum of all the 9 and above, is probably accounts collectively for just shy of 10%. So everyone is like, look, this is a big new fee, but it's only going to apply to a small percentage of the filers. All well and good, but I still think, if you're an applicant and for one reason or another you're prosecuting cases 9 years on, I don't understand why you should be penalized, but this is where we're at these days. So what can we do about it? One thing is to consider, advancing the timeline. So if you file a provisional first and you're going to convert to non-provisional, I would say the vast majority of the time we do that in a year, right? Well, maybe you're going to start doing that at 6 months, or you're going to start doing that, sooner, so that you're not getting into these, so that you can effectively fully prosecute the entire family more quickly. And obviously, just 6 months on a single case may not seem like a huge change, but if you know you're a serial filer, if you're in a in an environment where there's a lot of litigation and you like to keep applications alive for purposes of litigation strategy, this is something where, there's going to be some gives and takes. And of course, advancing conversion and advancing prosecution advances your cash flows, right? So you're going to be doing more prosecution, filing more apps over a term. And so you might think about, okay, if the old way was to spend 9, 10 years, and now we're going to do it all in 5 years. Well, you're going to compress all of that cost now into 5 years. So there's definitely gives and takes here. Um, so another thing, which is a similar idea, is filing concurrent continuations to address different claim scopes. So one, I would say, common strategy is, you start out with your first set of claims, they get allowed, you file a continuation, you go to your second set of claims, and so on, right? Until you think that you've gotten everything out of it. Well, maybe now you file, your priority case, and then you file 2 or 3 cons right away, and you approach those different claim scopes right away. That obviously helps with the timing issue. It may complicate other issues, like, one of the benefits of filing in a serial fashion is that you know everything that happened before. So for example, the art you're likely to see, the arguments that were successful and what wasn't. If you do that in parallel, then you're sort of learning in parallel, and so you may not get those advantages. But again, if you're the type of filer that has a lot of filings that are a long way away from your priority or your earliest benefit date, it may be worth thinking about, because $4,000 over a lot of cases is a lot of money. And then here again, trying to avoid unnecessary continuation filings, right? If you can push back against restrictions or put your claims in a way that are going to be more likely to be rejoined, even if you get a restriction, then you can avoid the divisional filings. Okay, and here we go. We're talking about maintenance fees. Someone asked a question earlier about them. So you see here, the maintenance fees followed the general 7 to 8%, and that includes not only the basic maintenance fee but the surcharges. One thing where the fee jumped significantly is a petition for a delayed maintenance fee, where the delay is over 2 years. You see there, that's the second to last row here, and it's a 43% increase. So quite significant. And this, again, if you line up all these things, you see the USPTO just wants you to get done with your prosecution quicker. They do not want, well, sorry, no, we're talking about maintenance fees here, so prosecution is done, but they also don't want you sitting around and deciding, maybe strategically, I won't pay that maintenance fee for a couple years, and then I'll realize, oh, nope, this patent is valuable, so I'll go back and try to say it was, unintentional. So this increased fee very much discourages any sort of behavior like that. One of the things that's quite interesting is, in terms of the USPTO's overall budget, maintenance fees account for almost 55% of their fees, and of that, about a third come from the 11 and a half year maintenance fee, which is, the last one, the big one. So, one of the things, and this figure over to the right, again, provided by the USPTO and the CFR, shows sort of, if you start out with patent A and you have 4 children and they're filed in a somewhat serial fashion, you see the maintenance fees that are likely to actually be collected by the USPTO. And as you get further out, the USPTO is collecting fewer of the high value maintenance fees, right? So as of child D, you're no longer getting the big 11 and a half year fee. And as of child E, you're not even getting the 7.5 year fee, right? So what can we do about maintenance fees? I think here the answer is, you've got to prune your portfolio, right? Especially if you're a high volume filer and you have a lot of issued patents. In various domains, the technology changes really quickly. I see, I mentioned that I do a lot of AI work. Well, the technology on AI is changing at such a rapid pace. And outside of very foundational patents, I could see several years from now, some applicants going, yeah, we have some candidates here for pruning because the technology just moved on. And of course, that will help save you from the increased fees down the way. Okay, what about AIA trial proceedings? So these are things like IPRs and PGRs, enterprise reviews and post-grant reviews. So these fees are up significantly. You see an across-the-board change of 25%, and they were already expensive. So these are quite significant, and probably are going to be most significant to applicants that deal with a lot of litigation, because these trial proceedings are very common as a a companion um, uh, proceeding to a litigation, right? So the rationale here by the USPTO is they want to maintain the appropriate level of judicial and administrative resources, and provide high quality decisions. So hard to say one way or the other whether that's really the driver. I think the driver here is to dissuade applicants from overusing these. There's been a lot of, and I won't go down this path today, but there's been a lot of discussion about 10 years on whether the PTAB has accomplished what it meant to and stuff. So this seems like just a barrier to entry to that sort of thing. How do you avoid these sorts of things? Well, one way is to increase your pre-filing diligence, right? And when I say pre-filing, sorry, before filing an AIA trial proceeding, right? So before filing something like an IPR. Now, in my experience, having done a lot of IPRs, you almost always do a good deal of diligence. Like, they're expensive. They're not things you just fly or file without, a lot of looking at. But still, now, I mean, with these costs increasing, I think it justifies a proportional increase probably in what you're doing on the front end to make sure that you have a better chance, right? Because it's expensive. Um, the USPTO suggests considering alternative dispute resolution, things like mediation. Um, all well and good. I think probably unlikely when you have contentious litigation, but still, it's worth thinking about if you can avoid this. Of course, mediation isn't free, but when these filing fees for the AIA proceedings, that's just one aspect of the cost, right? You're going to spend generally several $100,000 in total on these sorts of events, so they're expensive. Another thing is obviously streamlining the issues. If you're in a litigation and there's 2 claims out of 20 and a patent asserted against you, then there's no reason to challenge 25 claims, which would invoke some of the additional claim, the excess claim fees here. And then for patent challengers, and I actually see this quite a bit, exploring joint defense agreements where you can go after these and share the cost. And that's pretty common. All right. I'm gonna take a breath here. Thank you. Sorry, have I missed any other questions that you want to discuss before we get on to trademark stuff?
Yeah, there was one last question, and I'll go ahead and start sharing while you answer it. As part of these fee increases, did the USPTO consider moving to an annuity model similar to Europe that would address the scenario of less MF being paid on later continuation apps? The rationale the USPTO gives for increasing fees for filing old. That was the question that just came in.
Oh, so I have not seen any evidence that the USPTO is interested in following that model. I agree that it would definitely help with their problem, right? Because the big problem right now is that maintenance fees are paying over half the bill, and the biggest charges for maintenance fees are the farthest out from your filing date, right? So you're very backloaded. And obviously the way it works in Europe when you're paying annuities, even while the application is pending, so you're really leveling out the cash flow on applications and probably totally addressing that issue. And honestly, one wonders whether that's why you get an EPO office action versus USPTO office action, and the EPO office actions are just definitively higher quality. But yeah, I haven't seen that, and that would be it would be a major, major change to the way things have been done in the United States. It would obviously align pretty well with how things are done in a lot of foreign jurisdictions, but I think I don't think we'll see that in the next several years.
All right. So with that, I will take you over to the trademark side of the house in our last about 12 minutes here. I'll try and end on time, but if you have any questions, happy to stay over as well. So the trademark side of the house did also, as just with the patent side of the house, they did increase fees. We saw jumps as high as 66% or 150% for some that they created newly. And again, similar to the patent side, it's all about promoting innovation strategies, facilitating effective administration. So these are the stated goals here. Although I know there are some who don't necessarily agree that they're accomplishing these goals with some of the changes that have come through. So there are three big things to cover when it comes to the changes is how they impact your prosecution strategies here in the US. So the first is obviously the cost. So as you can see here, the trademark office, and these are actually the specific ones that they updated. I know Nick had mentioned he didn't reference all of them or he picked the ones that he thought were the most accurate. They didn't jack up everything. What they did was they increased very specific filings and then created a new fee for letters of protest. So here you can see we've got a range of as little as 8% to as high as 66% in terms of increases. And again, a lot of these are per class. So that really can add up for a lot of clients. The reason that you see here, there were two different fees for new applications under Section 1, where you're doing it based on use or intended use, or Section 44, where you're bringing it from a foreign country, either based on priority under 44D or an actual registration under 44E. Those two fees were based on the fact that previously you could pay a lesser amount if you picked something from the ID manual, or you could pay the standard fee rate of $350. Very few times were we able to use ID manuals for a lot of client filings. So I think most people seem to go with the $350. So that shouldn't be too much sticker shock there. Although, as we're about to talk about, there's plenty of sticker shock coming for clients that might be used to that $350 number. So that's kind of the increases that you should be expect to be seeing for your different filings. And there were a lot of clients who tried to do filings before the January 18th implementation, but not everyone was able to do so, especially since we only really heard about this probably about mid-December, and it kind of dropped quietly. So there wasn't a lot of time for budgets to allocate resources to make these filings early, but some folks did get lucky. So in addition to the fees, the second biggest thing to know is this introduction of the surcharge for using the text box for your identifications of goods and services. So all of us who have done trademark filings know you don't get to just claim everything in a class. In the United States, you have to have actual descriptions of goods and services. I think probably everyone on the planet that was doing US trademark filings was primarily using the text box. And now the USPTO is really trying to drive filers to no longer utilize that, or they're really going to pay a penalty. And it's a $200 charge for use per class. And that is only for 1,000 characters. One of my favorite parts of this is that you would think, okay, well, that doesn't include punctuation and spaces, but it does. So if you're trying to bring in a really long ID and you're going to base it off of 44 and not go through WIPO, you need to really think about how much you want to file when it comes to those really long IDs. So spaces and punctuation count. They're really pushing for us to use the ID manual. That manual, that's where you don't get the $200 fee. But the problem is pre-approved IDs may not fit. And that's what we're really running into now that we're about 2 weeks into these new rules. And the interesting thing is, even if you were to type one of those pre-approved IDs into the text box, it's just the basic use of the text box that gets you that $200 fee. So this is probably one of the biggest changes that you will be facing as you go forward, is either trying to fit what your client is doing or what you are doing into one of those pre-approved IDs, or having to bite the bullet and pay those extra $200. And I'm seeing a lot of clients so far that are like, I need to use this description. And so they're going to just go ahead and pay the higher fees for that text box. For those who haven't used it before, the ID manual is a searchable database of approved IDs. You can go and you can type in, so I did financial services as an example, and you can see all the different options here. So for some clients, it may be easy. Maybe if you are, an advisory service in the financial space, it's an easy option for you to take 036-1371 and use that for your application. Hopefully, a lot of your clients are going to be that lucky, but it's not always the case. The good news is that the ID manual is updated weekly. IDs can not only be added, they can be removed. And here's an example when I searched computer services where they've scratched one out. So now you have to go with others. Not all of them are complete, as you can see in this example. Some of them have for and then specify purpose or other blanks that you need to fill in. Editing these blanks should not trigger the $200 fee under the guidance given so far, but there is a caveat that if you are clearly abusing the system, there's not much guidance on what that standard is or when you meet it. But if you are clearly abusing the system, then you may still be charged the $200 fee, even if you use one of those pre-approved IDs. This should not apply when you are doing office action responses and you have to edit identifications based on the examining attorney's, thoughts and pushback. But again, I think it's still subject to that caveat of clearly abusing the system. So as long as you're not clearly abusing the system, when you fill in those blanks, if you make innocent mistakes, like you put something that maybe belongs in another class, or maybe a little inaccurate or indefinite, you're probably still going to be okay and not be subject to that charge. For example, if you said headwear, namely football helmets, that might actually belong in class 9. Or if you were to say maternity clothing, namely sportswear, that would be considered indefinite and need to be clarified. Those shouldn't be taken as being abusing the system, but there's not much guidance as far as how much leeway they're going to give applicants who are just being genuine and honest and trying to fill in those blanks. If you do leave it open, that will trigger the $200 fee. So just a warning there. It also applies if you put in the broad header. So if you say clothing, namely clothing, that will also get you dinged with the $200 fee. And again, that is per class. So it can start to add up with really big applications. The other big change, and I'm going to talk about some recommendations when we get to the end here, but I wanted to introduce these three for you guys first. The other really big change is the introduction of a new surcharge during examination for missing or incomplete information. Now, some of you have been practicing as long as I have. You may recall when they introduced the $50 discount at the trademark office if you were to use those pre-approved IDs, but you could potentially lose it if the examining attorney decided that you had failed to include something you should have. And I ran into that a couple times, and there was a lot of frustration early on due to the arbitrary nature of how this was imposed. And I think we're going to see something similar to that with this $100 surcharge because the categories are very similar, although it will probably be much more expensive than the ones that we dealt with years ago. So what does this mean? Well, these are the categories that can trigger that $100 per class fee if information is missing or incomplete. Some of this is, pretty straightforward and you probably will never have it missing from your applications, but others get a little more complicated. And we'll talk about that in a minute. So the first is, basic applicant information, their domicile address, citizenship, and other corporate info. I would caution against using care of addresses under this new rule regime because that may be seen as not providing a domicile address. And instead, what you should do is insert the address and include the request where you click the box to keep that domicile hidden if you're dealing with individuals or folks that should be protected from disclosure. If you don't pay filing fees for some reason, that will get you a $100 surcharge. Specimens, we'll talk about that in a minute, but if you don't include the specimen, that is definitely going to get you a $100 surcharge. If you don't include images for stylized or design marks, that'll get you the surcharge. This is the one that's not very popular with folks, color claims. If you make one, there is a question as to whether, the way it is worded, that if you don't name the color properly, if that could potentially subject you to an arbitrary $100 surcharge because you used the wrong color description. Descriptions of the mark are also included here, which is another note for concern we'll talk about in a minute. English translations, living individual consent statements, or stating that the mark does not identify a living individual. That's another one that's in there. Prior claims of registrations for the same mark where a different owner is listed at the USPTO. This is something brand new we've never seen before. And it seems to be focused where you have potentially the marks are held by a different owner, so you can clearly say that they're connected. But there's not much guidance there. So that's a big one, making sure that you include those. And then if it is a non-US domiciled entity, you have to have a US attorney or you could be subject to that surcharge. Probably one of the more frustrating parts of this at this point is that there's really no formal appeal process to contest the decisions of the examining attorneys here. The guidance pretty much so far says take it up with the examiner or their supervisor, but there's really no remedy mentioned. And given that petitions to the director have gone up quite significantly cost-wise, it may actually make sense just to pay the fee as opposed to paying an attorney and the fees involved with the petition to the director, which I think is one of the reasons why you're seeing a lot of frustration from folks as to these new rules. Same as on the patent side of the house when Nick talked about all the feedback that was given and maybe heard in some instances, but not all. So what can you do? So our recommendation, now that we're living under these new rules and having to try and fend off these surcharges, and for all of us, these apply to applications filed after January 18th. That means with the current U.S. Trademark Office delays of about 8 to 10 months, we're probably not going to really start to see what happens with these until about Q3 of this year. And that's when we're really going to start to get more guidance and a feel for how these will be treated. So it's these steps now that'll hopefully prevent some added costs as you get into later this year. The first is take advantage of the fact that you can submit proposed IDs to the ID manual. Like I said, they update it weekly. And if you've got some pretty standard language that you're using, it may make sense to submit those. We've done it once for one of our clients. It was accepted. You really don't get any kind of response back, yay or nay, but if it does appear, then that can make your life easy. There is a little bit of guidance. One of my team members, and I'll give him a shout out, Michael Fry, who's been as passionate on this topic as I have, he shared that there was some pushback during one of his own submissions where he submitted, where the trademark office basically said they couldn't accept it because it was part of a pending application. So we're not 100% sure if that guidance would still apply now, but it's probably a good rule of thumb. Don't try and submit something that you've also got a recently filed or pending application for, because it may get rejected and you'll have to wait until the application either proceeds to registration or goes abandoned. So just a heads up there. As far as the mark descriptions, there's not much guidance as to what exactly is going to trigger that $100 fee. Is it if it's missing, or if they feel like they want to reword it, which, you know, for a lot of us US practitioners, how often do you get that mark description asked to be reworded? Almost every time, right? So if you do have similar marks where you can mirror some of that wording, we think that that's a good idea to go forward and hopefully try and avoid that $100 surcharge there. For the listing all prior registrations of a mark, it's really unclear as to exactly what that means. The guidance that appears really indicates that where the PTO records do not list the most recent owner. That would seem to imply that your TSDR listing, which isn't always updated, if that doesn't have the right owner name, then you should include it. But the assignment that's in the chain might actually include the owner name, and it's not clear if that's going to be a get out of jail free card. So when in doubt, you may just want to list as many as you can to at least show that there is some kind of relationship there, especially if you know that different owner names are appearing in the TSDR. Number 5, this is where there's a bit of a split among practitioners who are talking about this right now, is the English translations. So a lot of times your client knows of no translation, there's no translation intended, and then the examiner goes on Google Translate, pops it in, and oh look, there's, you know, some potential obscure meaning in another language. To avoid that potentially triggering a $100 charge, there's 2 schools of thought. The first is include a miscellaneous statement where you basically say, here's all the potential translations found online, none of these are intended. And the other is to include a miscellaneous statement that there is no intended or known translation known to the applicant and none should be required. We have absolutely no guidance at this time if either of these approaches will work, but it seems like the general consensus is to do something with the initial filing where you pretty much put it into that Google Translate box and try and get a sense for what the examining attorney may find. So whatever way you decide to go, there's no clear right way or wrong way, but hopefully if you take that added step, that will be seen as providing complete information and won't trigger that $100 surcharge. Closely check your specimens. There's absolutely no guidance yet as to whether or not the surcharge will apply if the examining attorney thinks the specimen is just insufficient due to material differences in the mark and specimen. Sorry, let me take a step back. If they are found to be material differences, that we do believe that $100 surcharge will be applied. But it's a little unclear as to whether or not you'll get the $100 surcharge if the specimen just is unacceptable in the eyes of the examining attorney. So make sure you really check your specimens with your clients, with yourselves, to make sure that you've got the best specimen possible and it really has the mark properly in there to avoid that surcharge. And then finally, another idea is to file single class applications. One of the concerns that we have going into this is that that $100 surcharge applies per class. And some of the more recent guidance has indicated that it could apply even to classes that have been deleted. So if you delete a class in response to an office action, you still may have to pay $100 for that class, or added later on, you may end up having to pay another $100 for an added class. So it might make sense to do single class applications to try and avoid the high surcharges, and go from there, because you never know when that incomplete information is going to pick. Is blue versus light blue going to be an incomplete response? Mark descriptions, all kinds of things. You want to try and avoid those by separating it out into multi-class applications or to single class applications where you might have done previously in multi-class. So with that, I know I'm 4 minutes over. I'm going to go ahead and stop. I don't see any questions coming through. So I'll go ahead and stop sharing my screen and just take a quick moment to say thank you to all for joining us. As I said, if you're interested in a certificate of attendance to submit for CELIA credit, please let us know and we will happily go from there. And then I'm going to let Nick talk as well, but thank you, and we will ensure the recording and some of the slides are sent on for those interested. Go ahead, Nick.
Yeah, first of all, my apologies, April. I didn't realize I ran over my slot significantly.
You're
So
all good.
very well done in getting through your material. Sorry. I just wanted to very quickly, I had mentioned an example and it turns out it was in a different presentation. So I pulled the graphic real quick and just wanted to share it because there was
Yeah.
a question about it. So let me go here and share this and let me know if you guys can see that.
Yeah, all good.
Okay, so this is an example of patent advisor data, and what you see here is this examiner, very bad ETA, which means you're gonna do a lot of prosecuting. Total allowance rate of 33%, which is 20% under what the art unit is. So from a prosecution standpoint, this is bad news. But if you go down here to appeal, you see, and sorry, the number is small, but the chances of winning on appeal, 87.7%. So this is, and this is an examiner I've appealed many times now. So this is the sort of thing where, again, the data suggests rather than doing RCEs, do appeals. And that's it. Thank you so much, everyone. And again, I apologize for using more than my share.
Oh my gosh, no, you're fine. Thank you guys so much. Appreciate your time today, and we'll be happy to share the slides and the recording with you. Thanks so much.